Hello, everybody, and welcome to the MacroPro and Friends 12 CEUs of Christmas. And I am joined by Frank Fairchok. And Frank is going to be our expert today. He's going to tell us all kinds of really important information. Frank, how are you doing?
I'm doing great, Diane. Thank you.
So we are close to the holidays. Are you hosting? Or are you going away? What are you doing for the holidays?
I will be going away and traveling to see some friends this year.
Oh, that's
So,
very
yeah.
It's nice not to have to do all the cooking and such. So let's ask our audience. By the way, Emily says that she likes your hat, Frank. So thank you, Emily, for that comment. We appreciate that. So let's find out from our audience if they're going to be a home or away. So if you could put that inside of the box, and I see, or Stacy says she is hosting. I'm hosting as well. I host every Thanksgiving. We have rotating holidays at my family, so that's what we do. Sarah says that she is. Oh, hi, Sarah. I know Sarah. Yep. Let's see. Terry's going to be home. Iris is going to be away. Home. Oh, there's one that says home, and then it's got little. I thought it was going to be home alone. Hi, Marietta. Nice to see you. There are people that are hosting and traveling. Now, those people are truly gifted if they could do all of that. So very nice to see so many responses. I will read most of these, but you guys are amazing, especially the ones that are traveling and hosting. All right, so before we get started, I have just a few things to say. So you're going to get your certificate in Santa speed. You will get that in 1 hour after this presentation. Now, we just had somebody ask us for their certificate where they phoned in. And as we've said many times in the past, you cannot phone in and receive it. You have to be logged on to GoToWebinar in order for GoToWebinar to be able to take your time and your attendance, and they send out the certificates. If you are having issues downloading it, please be sure to let your IT department know to see if they can figure it out first. It's usually a firewall problem, but if not, you can certainly reach out to me within 30 days. After 30 days, I can't help you, but within 30 days, if you have an issue, please let me know. All right, so if you have a question for Frank, you can put it into the chat box. You got one for me? I can also answer that. So just put it in the question box and we will have that answered for you. And then lastly, there are handouts to this presentation. So please make sure that you download them. So you have all of the holiday gifts that Frank is going to give you in this webinar. And then now it's really lastly, you can watch this edition on the MacroPro YouTube channel. So if you want to see it again for any reason, it'll be there for you. All right, Frank, I'm going to leave this up to you. I hope everybody has a great, informative webinar.
Thank you, Diane. Okay, so we're here today. I think some of the emails that went out said Santa's gift to the RREs. So we're going to talk about the civil money penalties final rule. And before I get started with that, just a little bit. So I've been doing this for a long time. I've been doing Section 111 reporting going back all the way to 2010. If anyone out there knows a bit about Section 111 reporting, it's very complicated. It can be a little bit boring too. But I've been doing this since 2010, and I have to say, right, since then, right, these looming penalties, right, the legislation that went through in 2007 created these civil money penalties, and it was out there as up to $1,000 per day per claim for non-compliance in this area. So truly, Santa's gift. We got the final rule came out in October, and I'm going to really get into a lot of detail around this. And it didn't look like anything that we expected, right? We got the proposed rule information out in 2020. There was lots of feedback to CMS, and so we were waiting, and we expected to have the final rule in February of this year, and CMS delayed it. Well, it did come out in October, and it truly is a gift because we're going to compare what we were expecting versus what we received. All right, so here's some key points, things that we're going to talk about. We're going to get into each of these things in a lot of detail. So the final rule came out, it was October 11th, right, with an effective date of December 11th, 2023, but it's not applicable till October 10th of 2024. So we've got a year to prepare before CMS starts to impose these penalties. It's only for untimely reporting, right? And like I said, I'm going to go into what we expected, because we expected this to be very complicated. So it's only for untimely reporting, and a very limited number of claims are going to be reviewed by CMS each year. So they're going to use an audit approach. They're not going to systematically review data and just start penalizing, every single claim that meets certain criteria. But it's also, the focus is turned to the timely reporting of ORM and TPOC, right? So ongoing responsibility for medicals, right, which is the ongoing responsibility to pay for those medicals, right, if they're related to the claim, and the total payment obligation to the claimant, right, the fancy CMS word for the settlement, right, all dollar amounts that go towards that settlement. We've got an appeals process that's been included. We know that it's going to be a 5-year statute of limitations, but we've also got some safe harbors. So CMS really took a lot of the feedback that was sent into them and crafted some safe harbors so that the RREs would know, responsible reporting entities, right, using these acronyms, would know, right, if they encountered a situation where somebody wasn't being wasn't willing to give their information and whatnot, that there'd be some safe harbors for that. And I probably most importantly, right, tiered approach for non-group health plans in terms of how the penalties will be stacked up. And I'm going to go into, that's one of the best parts, and so I'm going to go into that in quite a bit of detail. So this document that came out, right, that landed on the Federal Register on October 11th, and it was a 37-page document. So the first 30 pages, right, weren't the actual rule itself. The last pages 31 through 37 were the actual 42 CFR 42 and 45 CFR 102. But the first 30 pages gave an analysis, right, gave the background around civil money penalties. It gave an analysis as to the public comments that came out back in 2020 or were submitted to CMS in 2020. And it gave provisions and kind of talked through what CMS's thought process was around moving the civil money penalties in this particular direction. So that 37-page document, right, only the last 7 pages actually have the rule itself, but the first 30 pages gives you all the background information as to how the decision was made to move towards this new process that CMS is going to employ. So, proposed rule versus final rule. And this is this page right here, right, summarizes Santa's gift, right, CMS's gift. What was proposed by CMS back in 2020 had several different components to it. So the first was, right, if you, in terms of doing Section 111 reporting, you report to CMS on a quarterly basis. And if you have errors, CMS pre-processes that file that's sent. So if you send them 1,000 claims in that file, right, they pre-process it and they try to determine whether the information that you sent into them is accurate, complete, right? They want accurate and complete data. If they find that 20% of the claims that you sent in are not accurate and complete, so they fails the validations, maybe data isn't included in certain fields that are required, right, they will reject that and send the RRE, right, a notice saying you've got to redo this file and resubmit it. So the first area that the proposed rule was going to hit was if an RRE had 4 out of 8 consecutive reporting periods where they were getting that error threshold, CMS had outlined how they were going to find that RRE for sending those bad files in, right? And if you sent in, right, 4 out of 8 consecutive quarters, but then kept sending them in, CMS would gradually increase each quarter. They'd increase that penalty against that activity. So that was the first area. The second area was whether an RRE was reporting late TPOCs, late settlement information to Medicare, right? And we kind of expected that one. We were thinking from the start that we were going to see, right, that because of the compliance flags that have always been part of this process, that CMS would be looking at whether you report TPOCs or ORM termination late. And so that second part, right, if TPOCs were reported more than a year late, past that date of settlement. And the third area, right, and this was, I think, probably the scariest for anyone who was taking a look at this. It was whether the reporting, the Section 111 reporting, right, contradicted the recovery side. So we send in data to CMS in that Section 111 process, right? All that claim data goes in, right? ICD codes go in as it describes the injury. And then over on the recovery side, which we call it conditional payments, right? CMS takes a look at that Section 111 report, and they determine, if they've made any payments that seem like they're linked to that report that came in. And so the idea of this number 3 was that if you got a conditional payment, right, and you went to CMS and said, well, hold on a second, we reported an ICD code or a couple ICD codes that really shouldn't have been sent in. There was a mistake, it was put in there. We've been living in this area where CMS would allow you to dispute the conditional payment and then fix your reporting so that the reporting would be accurate, right? And we were able to do that for many years. But with the final rule, that was what CMS was proposing, was that if those two things contradicted each other, so if you went back to CMS and said, I reported incorrectly, that would be a finable situation for them. So that was the proposed rule. That rule that came out in February 18th, 2020. There was a 60-day commentary period that went through April, and they got 46 really detailed responses back. So CMS started, taking a look at those responses as compared to what they had proposed. Well, the final rule that came out this October, right, is only going to look at untimely reporting of TPOCs and ORM acceptance, not ORM termination, right? So they're only looking at making sure that the claims are sent in, right? And we want to make sure that those claims with ORM or TPOCs are reported before a 1-year lapse in time happens. 1 year is the trigger point that CMS will say, you've reported this claim late. So if you look at that, right, everything else around that proposed rule, right, the contradictory reporting, the exceeding error tolerance, and the reference to ORM termination, right, that's all gone. And that is, I think, very relieving to most of the RREs that are out there. So timely reporting, simplified approach, right? And this, what I've got on the screen right now, right? These are some excerpts that came right out of this final rule. So CMS really, took to heart all that feedback, and they wanted to simplify this. And they also, right, there was some motivation to do this as well, because CMS has to live under, right, their scrutiny as to what the final rule would look like, as to whether it had a major financial impact or not. So there was some concern on that side as well. But I wanted to just point out, so right, in the bold type that's on screen, right, that the focus was not to punish and impose consequences, but instead to motivate proper reporting, right? And so that was where CMS was going with this, and we're very fortunate, right, because it is a very simplified approach. So this new process, right, that CMS is building, and it's important to know that they are building that right now. So this came out right in October. We've got a year to kind of get ready for this, and there's a lot of details that we don't know yet. And CMS is collecting questions right now, and they're going to review those questions. And at some point, probably in first quarter of 2024. We'll see, a webinar come up where they're going to want to discuss this and answer questions, and and start to prepare all the entities out there that have to report. But what the plan is for CMS is that they're going to do a random sample audit, right? So they're going to be looking for this random sample of claims each quarter, rather than reviewing all the data, right? Because there's, on the non-group health side, right? Non-group health being workers' comp, liability, and no fault, claim reports, right? There's millions and millions of claims that are reported each quarter, right? So what they're going to do is come up with a plan to randomly select samples of the claims that are sent into them, and they're going to do a review. They're going to take a look, manual review of the records, rather than a mass algorithm processing it, just churning out lots of potential suspects for late reporting. And they're going to use an informal notice to let the RRE know that there's an issue. And I'm going to go into that in a bit more detail. But that's, they're really looking, right, to make sure that, in terms of what's going on out there, good faith efforts, to report claims, they want to give the RREs the ability to respond to that informal notice. And right, if there's other information that CMS should be taking into consideration, then that's important as well. So it kind of meshes the race. So ORM and TPOC, ongoing responsibility for medicals and total payment obligation to the claimant. So CMS is just looking for whether those two items have been reported late. The thought was, right, that ORM termination, because ORM termination is really important to CMS, because if you report that you've got that ongoing responsibility for that claim and it has terminated, but you don't report that termination, right, they aren't going to show that, right, that responsibility has ended on their side. So it winds up perhaps generating more conditional payments down the road than should be generated for that particular claim. So we thought ORM termination was going to be under that scrutiny, but it's not. So there's no penalty for reporting ORM termination late at this point. It's just reporting that ORM, when it's established, timely in the first place, within that first year after ORM is accepted. And while we're on this topic, right, keep in mind, so there's no, in the data fields, there's no ORM acceptance date itself, but there's a date of injury, the CMS date of injury, and that date of injury winds up being the ORM start date. So what we want to do is make sure that we are reporting any claim that's got ORM, right, with that date of injury, right, within a year from that date of injury. And on the TPOC side, right, the TPOC date is the date that the settlement has occurred, and we want to make sure that those are also reported within a date or within a year of that TPOC date, once that's established as well. Right, so why an informal written pre-notice? Well, CMS felt that this was a really fair way to deal with, notifying the RRE. So, right, this pre-notice, right, is where CMS is going to go to the RRE and say, we think we have, right, a claim that we need to review with you, and that allows the RRE to then start, taking a look at what other mitigating circumstances, right, might be, they need to bring to CMS to let them know why that was reported late. If you get written pre-notice, right, you'll have 30 calendar days to respond with any of that mitigating information. So, right, maybe some of the mitigating information could be, right, that, on the technical side, it could be where maybe CMS's system didn't accept, right, the SFTP upload of the claims. There are times when things like that happen, and CMS wants to make sure that, right, that it wasn't their fault. They want to know what happened with the claim. And they didn't want it, the last time on this particular slide, right, impractical to regulate or enumerate all mitigation options, right? So they didn't want to box the RRE in into only, being able to provide certain pieces of information, right? So anything that the RRE thinks is of value to the consideration as to whether or not that moves forward with penalties, right, can be brought to light in that written informal written pre-notice. So if CMS, right, determines that a penalty is warranted in that situation, right, it's going to move to a formal notice, right? And so the formal notice will contain the information about, what CMS is looking at to penalize for there, and it will contain the amount of that proposed civil money penalty, that CMP. And that's not the end of the process, right? So you can see here that the next steps for the entity would be to start to appeal that process. And there are several steps to that appeal, which we can see right here. So the formal written notice, right, once that's provided, right, the next step would be to, the RRE has the right to request a hearing with the administrative law judge, and they have 60 calendar days of receipt of that written notice to move it in that direction, right? Once that ALJ makes that decision, right, that there can be an appeal of that. So within 30 days of that decision, right, any party may appeal the initial decision of the administrative law judge. It's just got to be timely. So these things are going to have to be monitored, right? Otherwise, you're just going to keep moving forward. And then once that's done, right, there'll be a decision made, right, and that decision becomes binding. So the Department Appeals Board, right, will make that decision, and the decision will become binding on that particular written notice. So there's, just because you are selected, right, and I'm going to go into this. I have heard this called a lottery in terms of how the claims will get selected, and I'm going to go into that a little bit more. So there's probably a fairly low chance that a claim, right, for a particular RRE could get selected. But even if it does and it moves a written notice, we've got steps that we can take to try to appeal that decision. All right, so statute of limitations. There was a lot of buzz around this, and so in the rule, right, CMS says that that the statute of limitations is a 5-year period from the date when that non-compliance occurred, and they actually gave some pretty solid information around that, right? So because there was discussion as to whether it should be 3 years, 4 years, right? But because of the underlying statute, right, they've decided that it is 5 years, and I think they have a pretty solid ground as to imposing that as a statute of limitations around CMPs. All right. So this is one of the questions that I think, the big questions that I've received over the years. Somebody always asks, right, when you're talking, who's been penalized? Has anyone been penalized, right? And so no, nobody's still on the non-group health side. Nobody has had a penalty yet. But the other question is it looking forward or looking backwards? Is CMS going to go back years and take a look at data that that you could have reported a couple of years ago? And they're not going to, right? It's prospective only. So they're looking forward for this. The final rule becomes effective next October, and it will take CMS probably until the October of 2025 to really get to the point where they're actually penalizing RREs for this. But it's a look forward. So at this point, if you have a claim that was reported incorrectly 3 years ago, there shouldn't be any issues with that as long as it was reported, right? And you don't have to do something to resubmit that data that would enable that claim. It is a look forward, and I think that's also part of the gift, is not having to go back and worry about historical data that's been out there where an RRE may not have had their eye on the process quite as tightly as they should have. All right, so safe harbors, right? So there's two big items on here. So CMS has said, right, that these two areas would be where there wouldn't be a penalty. But one of the important things that you have to keep in mind with both of these safe harbors is that document, right? Document, document, document. You want to make sure that if these scenarios occur, that you've got great documentation in place so that you can go back to CMS and say, this is what happened on this particular claim. So on one hand, right, CMS has said, right, if there's some sort of reporting problem, it could be a technical issue, right? So, it could be, as I mentioned earlier, sending the files onto the SFTP. There are times when CMS's systems are down. I've seen, right, in the last, almost 14 years now, probably millions of files that I've seen in terms of transferring to CMS, the query files, claim files. Things don't always work great. You have to have processes in place to go back and review that activity and make sure that everything is working the way it needs to be. But if you were to try to send a claim file to CMS and there was an issue with the SFTP, right? That could be one problem. Or right, that the SFTP connected, the file transferred, and then CMS did something on their side where the file didn't get processed, for example. So those types of technical issues where CMS and its contractors are responsible, right? That would and that makes logical sense, right? That they wouldn't penalize because they knew that the issue was on their side. So that's completely right, logical. They're taking responsibility for the concerns that they might be creating. But on the other side, right, if there is right, in order to do Section 11 reporting, right, you need certain pieces of information to start the process, right? The first hurdle to report a claim is determining beneficiary status, right? You only report beneficiary claims to CMS. So in the workers' comp area, we don't have a lot of issues because usually workers' comp are employees that you have all that information. So you've already got the social security number, right? And you've got first name, last name, date of birth, gender, right? But a lot of times on liability claims, we have issues, right? Those sometimes, those claimants don't want to provide that information. Their attorneys don't want to provide that information. We've come a long way since the early days, and I think it's been socialized quite a bit as to why that information is important, right? It's required, it's important, and there are repercussions even on the claimant side and their attorney side if they're not providing that information. But there are times when you cannot get that information. So if it's a lack of cooperation by the beneficiary, right, then that will not lead to a CMP. And in this particular case, right, again, that documentation is important, right? CMS has a letter that's available on their website that if you're looking to get that social security number and that those other query related fields, you can send that form letter and ask them to fill that out. So CMS wants several attempts to get that, and they want you to use different methodology too. So maybe you're sending that email twice with that form attached. Maybe you're trying to call. But in the rule, right, there's a provision that basically states that if you are told in no uncertain circumstances that you are not getting that information, that you have that documented, right, and hopefully be written documentation, then at that point your obligation is fulfilled. So two of the safe harbors around this process that CMPs would not be imposed for. All right, the tiered approach. So first thing I want to talk about here is, right, NGHP, non-group health, right? Workers' comp, liability, no fault. GHP, group health, right? So GHP is your Humana, right? All the big, United Healthcare, all those big healthcare plans that are out there. The GHP plans have an obligation to report data to it. They do it in a slightly different manner. The main process is very much the same, but the data elements are different from what we would collect on the NGHP side. So years ago, this organization called MARC, right, Medicare Advocacy Recovery Coalition, kind of got involved with some of the organizations on the NGHP side, and they've been out there kind of soliciting, working, to try to get CMS to be kind of common sense with this approach. And I think they were really instrumental in helping us get to where we are today and not having that proposed rule items become our reality. But unfortunately, right, the GHP plans, GHP organizations out there did not have Mark out there working for them. So on the GHP side, the penalty still is $1,000 per day per claim. It's not up to 1,000, it's $1,000 per day per claim, and there's no cap on that. So the GHP side of this is in much worse shape as we move into that. But on the NGHP side, because we had the SMART Act that came out in 2013, right? The SMART Act gave CMS some discretion on the NGHP side. And the SMART Act amended the wording to up to $1,000 per day per claim, not mandatory $1,000 per day per claim. So on the NGHP side, CMS was able to modify that schedule or that tiered approach. They give us that tiered approach as to how they're going to levy those penalties, right? So really, really great news for us. I'm going to show you what those dollar amounts are, but the all the dollar amounts also, right? Because $1,000 per day per claim is pretty bad, whether it's GHP or whether it's the modified amounts on the non-group health side. But the other thing that we have to contend with is that there is the potential to modify these fines based on inflation. We all know what inflation's been doing lately, right? So you can see on that last item there, right, that $1,000 per day per claim, right? If you looked at what the annual adjustment would be as of June 23, right, it's actually $1,325, and that's going to be adjusted, right? Every year there's an adjustment made for that. So those GHPs are actually looking at over $1,300 per day per claim. And if you're hitting the maximum penalty on the NGHP side, you're gonna see that as well, right? But you have to report something really late to get up to that, and we are on the NGHP side capped as to how much that penalty can be. All right, so a little, show back to unable to obtain necessary information, right? I kind of talked about this a little bit. So, right, last name, first name, date of birth, gender, MBI, or SSN, or the last 5 digits of the SSN. Those are the data elements, right, that we put into that monthly query file that we send to CMS, and they match those elements, and they come back and they give us 2 pieces of information. Well, it's more than 2 pieces, but the first thing they do is they say we either matched it or we didn't match it to a beneficiary record, right? Because first hurdle for reporting, beneficiary record. The other thing that comes back now in that query is the PAID Act that happened a couple of years ago. We get all the, if that beneficiary is on a Medicare Advantage plan, a Part C plan, or prescription drug plan, Part D, right? We get some data around that. We can see the last 3 years of the plans that they've been on. But right, attempting to get that information, right, in order to get that query, we got to start with that information that we collect around the SSN. So if you are only able to get the 5 digits of the SSN, then it even gets a little tighter, because then we've got to match the other 4 out of 5 pieces of data. But if you get that information right, that's an important part of making that determination of beneficiary. So if you're trying to get that information right, and like I said, workers' comp usually not an issue, but in liability, it's been a problem for quite some time. So if you get a response, right, that they're not going to provide that information, right, and that needs to be well documented in the case files. If that claim comes up, as a late report not being reported, right, you want to have all that documentation in place, and you want to pay really close attention to, right, what CMS really wants in terms of the collection of that information. And one of the important parts of this is maintain the records for a period of 5 years. Any of that communication, make sure that that's well documented and that you can get to that information later. All right, so me go into some numbers here. Some good numbers here. Audit specifics. So what we're expecting right now, what CMS has laid out, right, is that they're going to audit 1,000 claims per year. But that 1,000 claims is broken out between group health and non-group health, right? So this is where it gets really good, because the chances, I think, of getting audited are fairly minimal. So CMS said in the document that around 60% of the claims that are reported every year are group health claims. So that means of the 1,000 claims that they're going to take a look at, they're only going to look at about 400 claims from the non-group health side per year. It's only 100 claims that they're going to try to audit per quarter for non-group health plans, right? So that's a really small audit amount compared to, thinking back that they could be looking at this from a system perspective, where they're just churning through data and collecting all sorts of claims to throw into the process for penalties. So I mentioned the lottery earlier, right? So there are millions. Well, so in terms of RREs, we think that there's around 20,000 NGHP RREs out there, 20,000. So 20,000 entities out there, and only 400 claims a year, 100 claims per quarter being audited. So that's, again, out of millions of reported claims out there. So that audit is going to take a look at a very small population of claims that are submitted into CMS, right? And they're going to do this as a random process. So, right, we don't know if there are any triggers that will come out. I think we'll find out a little bit more about that random process as we move into 2024. But right, they're going to randomly select this. So they may select a claim that was reported timely, and there's no civil money penalty around that. But they're looking for, right, the claims that have been reported, right, a year or more late. So if you sent a claim in, if you've reported a TPOC and you reported that TPOC, 5-6 months after the TPOC date, that wouldn't qualify for a civil money penalty. It'd have to be a year or more late. So really great on the audit part here, right? It's a really small population of claims. I think that's going to be a really positive thing for the RREs in this process. All right, so I mentioned a little while ago, right? Group health plans, they're kind of stuck at that high dollar amount. It wasn't an adjustment made, but because CMS on the non-group health side could modify that, here's what they've put together for us. So they're looking, right? The calculation for this is going to be like the days late will be every day past a 365-day period, right? So you get that first year of reporting late, and then once it goes over the 1 year, then the CMPs would start to apply. And here's how they're in the middle of the slide here. So if it's more than a year late, but under 2 years, right, the adjusted amount is $250 per calendar day for noncompliance. If it's more than 2 years, but under 3 years, they're going to bump that up to $500 per calendar day. And if it's over 3 years, right, they're going in at that full $1,000, right? And the cap on this is $365,000. So versus no cap on the group health side, the cap for reporting a claim late on the non-group health side is $365,000. Now that's going to wind up being, unfortunately, it's going to be higher than that, because it's still going to be adjusted annually for that inflation number under that 45 Code of Federal Regulations Part 102. So it's going to be a little bit more than that, but it's still, right, the cap is still great versus, the thought was that we would have potential of hitting a civil money penalty, right? And that number could be anything based on, CMS going back any number of years to take a look at that. So there's still risk here, right? We still have to make sure that we're reporting the stuff on time, because 365,000 or 400 and something thousand adjusted, right? That's still going to be very painful if that penalty becomes a reality. But way different than anything that we expected to come out from CMS. All right, so I'm gonna go into, right, this is kind of been my going off and sounding the alarms now for a couple years. Let's talk about, right, let's, the graphic here, right, the money is flying away. We don't want the money to fly away. So let's talk about some practical things that we can do, right, to make sure that, right, we're in good shape when we get into that CMP period at the end of next year. Pre-validate your claims before they go to CMS each quarter, right? This is super important, right? What you want to do is run the claims through, right? Try to figure out, right? We know there's a lot of data elements to this, but right, and CMS has a lot of different error codes that they can send back, right? That tells you that you've either sent, maybe you've not filled in data, maybe it's a blank, a null field that needs to be filled in, or maybe the data that was sent to CMS, right, isn't valid for reporting. Example might be, every claim has to have at least one ICD code on it, right? CMS won't accept the claim without having an ICD code on it. We're many years into using the ICD-10 now, so there's a lot of different codes out there. But of the codes that are available in the ICD-10 set, right, not all of those codes are valid for Section 111. And within that too, there are some codes that aren't valid for specific plan types within Section 111. So if you're reporting a claim and you're using a code that isn't on the CMS green list for codes, even though you're providing an ICD code in the slot, CMS is going to reject that claim and say, that ICD code is not valid. There's a lot of codes out there that they might be codes that are just kind of vague. Even in ICD-10, they might be too vague or don't specify a body part correctly. So those codes are out there. So you want to pre-validate your claims before going to CMS each quarter. Try to figure out, right, whether the data is going to be accepted by CMS or not. And if you have a really solid validation process, right, then those claims will get popped out, right? I also, as a strategy, don't send bad claims to CMS. If you know something, or if you know a claim doesn't have all the data elements included in it, or if you know that that your validation failed a particular claim because a piece of data isn't correct, don't send those claims to CMS at all. There's no partial credit for CMS, right? You want to send, each submission should be accurate and complete. So I think that pre-validation process is super important, right, to make sure that you're sending CMS good, clean data. All right, audit your processes, right, to ensure data is not trapped in your processes. What does that mean? Well, right, we're looking for, right, and CMS is looking for, they're looking for late reports of ORM, late reports of TPOC. So if you do have errors on claims, right, and you're aware that they're out there, make sure that your process ensures that they're going to be looked at, they're going to be reviewed, they're going to be fixed within a certain period of time. You don't want to have, if you have a claim that, if you do have a validation process and you know that this claim has failed the validation process, and it's just been sitting out there without anyone going in and trying to fix it. Because I worked with so many adjusters. Right? The adjusters have, claim handlers. They have so many things going on, so many things to view all the time. So, you might be getting a report. There might be diaries in your claim system, depending on how you're fixing those issues. And it's difficult to see everything at once. And sometimes it's difficult to put time aside to go and do those corrections. But if that data is sitting out there and it's not being submitted to CMS, right, the clock is ticking. We don't want the clock to tick up to that 1 year mark. So, right, we got to look at that data. We have to come up with a process that ensures that if there are claim issues, whether we've submitted something to CMS, right, maybe we submitted it to CMS and they rejected, at the claim level, they rejected a couple claims, those have to be fixed and resubmitted to CMS. But if they weren't submitted to CMS and they're just sitting there in an error status, right? We have to make sure we get eyes on those claims so that we get that fixed and it gets to CMS timely. All right. Third item, review your results holistically, not just claim by claim. So a lot of times when the results come back from CMS, right, you'll get that claim by claim, maybe the disposition information, maybe, right, that's loaded into the claim system, and you can see that. But somebody, right, should be looking at the whole result that came back from CMS. And the reason for that is because if it's fine to be looking at it claim by claim, right? Claim handlers know that they have to fix something, they're gonna fix it. But from a management perspective of this process, if you're getting a certain number of errors back, you want to make sure that you know what percentage that is. Yeah, and also that's a great opportunity to try to look at correcting that validation process, right? But if you're getting that response back and you're at 19% errors and CMS is going to reject the whole file at 20%, that's got to be reviewed, because that whole file being rejected pushes that submission back, could be months, right? So you want to make sure that you're looking at that holistic return of information to see the whole picture of what came back, right? And I've got on here, pay attention, disposition codes, right? You want to get O1s and O2s, right? You don't want to get those. SP is an error disposition code, and there are a couple error codes that come back within that SP disposition that you can't do anything about. CMS acknowledges that, but for valid errors, right, you want to make sure that you're taking a look at those disposition codes, error codes, and the compliance flags. And I want to just note on the compliance flags, we've had 2 compliance flags that we've worked with. One is around the late reporting of TPOC. The other is around the late reporting of ORM termination. That ORM termination, not going to be important anymore. And CMS is working, we got some information about a month or so ago that they're working on putting a new compliance flag for the late reporting of ORM. So that's what they're going to be looking for. And then, of course, as I've mentioned, right, I'm going on and on about this, but it's very important, document any safe harbor events and attempts to collect the data. Super important there. All right, so highlights, right? Again, super, wonderful gift. I know when I read the document when it was released, I was in shock. We've just been, for 3 years, right, with that proposed rule being out there, we just thought, that CMS was going to move in that direction. I know when I read the proposed rule in 2020. I was like, this is not well pieced together. There's lots of holes. I wrote a response to CMS. I was like, you really have to think this through and do a little bit better with this. So when it was delayed earlier this year, it's like, well, maybe that's what they're doing, right? So, right, came out, and right, we really just want to make sure that we've got our processes in place to make sure we're not reporting those ORM cases and those TPOCs more than a year late, right? It's not going to be looking at that ORM termination, so that's really, that's really good too. ORM termination is difficult sometimes for an RRE to determine, and it can get kind of cloudy, and so sometimes, right, the decision is made to not terminate the ORM because they're not sure if they can. So the fact that CMS isn't going to be looking at that anymore is a really positive thing, right? Statute of limitations, 5 years, formal appeals process, right? But all in all, I think that we really, as I've said before, right, we really got a gift with this final rule. And if you have any questions, right, you can certainly, if you have experts in this area, you can reach out to them. But the number 10 bullet point here, questions can be sent in to CMS. It's at SEC 111 CMP at cms.hhs.gov. So they're gathering all the questions. So you might not get a response back, but if you have questions around this, send it in there, because what they're going to do is they're going to take all those questions and they're going to incorporate it into the information that they bring out in 2024. So now is a great time to, if something's not clear, right? And we've got a list that we're building, make sure that we get clarification on everything, but that's a way to communicate to CMS if you have questions around how this is all going to become reality for us next year. All right, so I just want to wrap up the slide deck here. Yeah, I'm Vice President of Medicare Reporting for Impacts, right? We are a one-stop shop in the Medicare secondary payer area, Section 111 reporting, conditional payments and lien resolution, even if that means, right, if Medicare Advantage plans, we actually have a program to go after the Medicare Advantage plans and put them on notice that there's a primary payer. Any type of future medical allocations, Medicare set-asides, right? Whether it's traditional submit set-asides or whether it's a different flavor. We've got quite a few of them that are out there. We also in-house do, claim administration. So if you've got a claimant that, right, is going to be getting MSA money, we can get them into a professional administrative account so that they're using the money correctly. Structured settlements, and lastly, but certainly not least, settlement consulting. We have an amazing team. As we became Impacts, I was really just thrilled that we were having all these new people that were so well versed in everything Medicare related. So consulting needs, anything from claim review to settlement consulting, file reviews. That's what they handle. And with that, Diane, we can open it up to Q&A.
Yeah, so I do have one question. And this person said, well, this kind of a question statement. It says they understood that CMS removed the 20% error threshold. Is that correct?
So they have not. So the error threshold is still out there, and I don't see that they have any intention of doing that. So that's still a reality right now. There's two thresholds. There's the 20% error threshold, right? And so, if it doesn't matter how many claims you've got, if you're only submitting 5 claims and 1 claim is an error, that you're going to hit that 20% error threshold. And then the other threshold they've got is the 5% delete thresholds. So if you're trying to delete 5% or more of the claims that you're sending into them, they're going to stop on that one. They're just going to ask for clarification as to why you're deleting so many claims. But the error threshold still remains.
Got it. All right. Well, there are no other questions. Frank, I'd like to thank you again for being one of our speakers at the 12 CEUs of Christmas. I know it's been a couple of years since you joined us on our webinars, and we're so happy to have you back as part of our friends. As for everybody else, we do have more 12 days of Christmas or CEUs coming up. And just so you know what are coming up, I'm going to share that with you. Tomorrow, we're going to have what you should know about applicant copy services, and that'll be at 10 o'clock. We have acute rehab at 1:30 tomorrow. Then we have the various court systems and legal authorities that you will want to know about and how they play in the system and what you should be aware of. And that'll be the next day at 1:30 in the afternoon. All right, you can always look at the MacroPro website. All of our classes will be listed there. Again, you will see this presentation again on the MacroPro YouTube channel. And make sure that you download the handout right now before we close this webinar out, and you will be getting your certificate, like I said, in Santa speed in 1 hour, so that you have that. Frank, would you like to say anything else in closing?
No, I just want to wish everyone happy holidays, and I appreciate you taking time to spend with me today. Hopefully you got something out of it. Thank you.
There's a lot of great information. All right, everybody, till tomorrow. Bye-bye now.
Thank you, Diane.